Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Employees Compensation Amendment Bill 2016. To discuss the issue, I have with me Elizabeth, who is Senior Coordinator, Naari Shakti Manch, and Mr. D.N. Goburdhan, Advocate, Supreme Court. Now for the headlines. The bill provides for strict actions against employer if he doesn't inform employee of his right to compensation. The bill imposes and enhances penalty up to 1 lakh rupees on employers for violating the employment compensation law. The bill ensures that payment of compensation is not withheld. The bill deletes provision which empowers Commissioner to withhold compensation if an appeal is filed. The Employees Compensation Bill provides for stricter actions against the employer if he dilly-dallies in matters of compensation to the employee or his family. This compensation may arise due to injuries caused due to the nature of work or disease caused through certain occupational hazards.
There have been several incidents where the employer has used the existing law to his advantage to deny the employee his rightful compensation. But no more. The government has proposed changes to the employees' compensation law to ensure that the gaps in law are tightened. This will allow better implementation of the law.
They have made it mandatory for the employer to provide for the provisions of this act as to what kind of benefits are available under this act for the employees, for in case of injuries or occupational diseases arising out of the employment. So it is better step that the government is taking.
The bill makes it obligatory for the employer to inform the employee of his rights in both written and electronic means before beginning of the employment. The language for informing the employee about his rights can be English, Hindi, or in the official language of the area of employment. The bill imposes penalty for not informing the employee his rights of compensation. The bill increases the penalty for contravention of law from the existing amount of 5,000 rupees to 50,000 rupees, which can go up to 1 lakh rupees. The bill revises the minimum amount involved for which an appeal can be filed in the High Court from 300 rupees to 10,000 rupees. It also empowers the centre to hike the amount through notification.
Employees compensation bill, there are certain provisions that are welcome, as the increase in the penalty, making it obligatory to make the employee aware of their right to compensation, all these things. These are all welcome steps, provided, again, in all law there is always provided they are appropriately enforced.
Once the Commissioner has allowed payment of compensation, it will have to be paid and will not be withheld merely because the employer has filed an appeal in a higher court. The bill deletes Section 30A of the law, which empowered the Commissioner to withhold payment of employees if an appeal was filed in the court by the employer. The omission of this section can be seen as a big relief to the employees, as now the amount can only be withheld if there is any stay or order by the High Court. The Employees Compensation Amendment Bill 2016 was introduced in Lok Sabha on August 5, 2016 by the Minister of Labour and Employment Bandaru Dattatreya. Recommendations were made by the Law Commission to amend various provisions in the law to rationalize the penalties and strengthen the rights of the worker under the law.
Although the bill increases penalties for the violation of the law, but the question is whether merely increasing penalties would help in better compliance of the law, or more needs to be done to strengthen the enforcement mechanism. With cameraman Anirban, Dipali Pandit for Rajya Sabha Television.
Enforcement has always been a problem, but the law, as far as the structure for policy is concerned, it is very specific this time that a disclosure, specifically in the language that has been mentioned in the law, in those languages, electronically or otherwise, the employee will have to be informed before he begins his employment with the employer. Ma'am, straight away, the implementation part, that's where normally the problem is. You were mentioning that on the sections which will not be covered under this law, how do you suggest that section can be included for compensation issues? What needs to be done?
Yeah. Regarding this amendment bill, it's a good bill, but coming from the practical as well as daily experience of women working and of women working in organized sector but through contractors or as an unskilled labor in the helper states, especially in the factories, in the garment factories. One thing that needs to be mentioned in this bill is that those women who are or men who are not literate and who are not able to read and write before joining the work, they had to be explained about what is this compensation, how can they get compensation, what are the documents, if something happens, how to report to whom, that should be made very clear. Maybe in some like companies they might done, but as per our experience, most of the women who are working in the unskilled and semi-skilled level in these companies, they do not know about the certain things about this compensation.
So basically what you're saying is that the bill assumes that whoever is seeking employment has to have certain level of education, and that is why that is where the people who are illiterate or not informed or not educated miss out on it, because then the company can take advantage of their situation.
Yeah.
So that section needs to be protected further.
Yes.
Is that the point you're making, ma'am?
Whether in the rule book, it has to be mentioned.
Okay.
This is very particular because most of the unskilled and semi-skilled women who are working in these factories
End up getting exploited.
And sometimes, many cases also, they have to, because of the very nature of the work conditions and the employability conditions in these companies under contractuality, proving that they are a worker is also a main issue. That is the reason why they could not get compensation.
Now, that's where I'll get Mr. Govardhan in.
I think Elizabeth's apprehension is a little misconceived.
That may be right, but the issue of including or protecting the people who are not aware enough, who are not educated enough or literate, so to say, and they are the ones who come into organized sector as unskilled labor, and if the company faults, it's very clearly written that there's going to be penalty imposed. But if the person is not aware, so what needs to be done to protect that segment in the organized sector?
I would say first thing that this bill is a big leap in the air. It's a big protection to the workers, and it gives us very strong message to the employers that you can't take the people who work for you for a ride. Now, having said that, Elizabeth's apprehension is that a lot of women have not been told. This is a bill which is yet to be enforced. So this would happen in future. And the fact that the law takes care of it now, which was hitherto unknown, earlier it was not so. And when it says that the employer shall, the word is shall electronically or otherwise would mean that, as she is right, Elizabeth is right, most of the workers would be illiterate. Women will just be doing stitching work, button work, whatever they may be doing.
Correct.
The fact of the matter is that the onus is on the employer to explain, to tell either in writing, orally or with an interpreter, because there would be a document signed.
Correct.
And it is not so from time immemorial. If you see, even at that time when people were illiterate, people used to put a thumb impression. So I'm sure that even when a thumb impression is put, there will be a note saying that the person has been explained about his or her rights. I think the fact of this, I mean, why this is a big leap, as I said, was that now a workman will be entitled to know his rights or her rights. Earlier it was not so. The people would not know. I am only working in a factory. He is very happy that he is getting 100 rupees. Today, before he joins the employment, he will know that if any injury causes to him or her during the course of that employment, that he or his family will be given some compensation. So, see, that inner security is a big leap in this new bill.
But on the implementation part,
implementation is always not the part of the parliament. You please.
I get it. I get
that
it.
has to be done always from the lowest level. The inspector level, the sub-inspector level, and the commissioner who, in fact, if you look at the act itself, And I'll tell you one thing, when you read that act, this amendment is 2016, but the act is nearly 100 years old.
1920.
23.
Yeah.
And you look at that time, the Britishers, who are very capitalist oriented at that time, yet thought that the welfare of the employee or a worker who works for a capitalist owner or a manufacturer, his rights should be protected under a statute.
It's a progressive law.
Very, very progressive. I would say very, very progressive. And if the Britishers at that time, 100 years ago, could think that they will not leave this compensation business at the mercy of a lala or a manufacturer.
Correct.
And they left it to the wisdom of the parliament. So I think this parliament has done a beautiful job to make sure they have gone miles ahead to protect the right of this poor workman.
Ma'am, on the sections that have been not covered, who do not fall under the Employment Compensation Act, the 1923 Act, what is the mid path that the government needs to take in order to also bring them into the ambit? What needs to be done?
Regarding this one, the government needs to be clear in making it mandatory that a worker who is working at different levels. For example, sometimes we use the word called a worker who is a piece rate worker. He or she does not get his salary in his account, but by cash. The worker can take it on a daily basis. By
Daily
cash.
wages. You're talking of daily wages.
Daily wages, by cash or even in a weekly manner. But they took it by cash. They do not have an account that they are working in this particular company or they are working in this particular contractor who is working under a particular company. So when something happens to him,
he also should be compensated.
He should be compensated. Yes, the law is very good. The law will slightly touch about it, but where will the worker prove that he doesn't have a salary account, she doesn't have a salary account, and she doesn't have an employee's number or a tag? Then how can she prove or he prove that he's a worker to get this?
No, Elizabeth, that is very simple. Look, now
what are the loopholes that the manufacturers or employers actually exploit?
Correct. But now with this new section which has come, the moment it says that when I join the work, as a worker, when I join the company or the manufacturer, the employer has to inform me of the rights, failing which he will be punished.
So what if you're off the record employee?
No, that's the point I'm trying to say. That if I'm, as she says, that if I'm working in a company and the employer does not tell me, I can jolly well write to the commissioner saying that I'm working at this place, there are 100 people working here and this manager is colluding with your local man.
But do you think he will never get an employment again?
No, that's not the point. The point is that they will be exposed. You see, to say law can't be you can't say that this law is bad because enforcement is poor. IPC is bad because rapes are happening in Delhi. That's not the point in question. Look, there is a traffic light, there will be a red light and a green light. People will violate and will go past the red light. That does not mean
that there should not be a policy.
That's the point. So law has to be there.
Time for us to head into a break. When we come back, we will talk about the situations in which compensation will not be tenable. Welcome back. The Workmen's Compensation Act 1923 provided for payments of compensation to workmen and their dependents in case of injury or any disease caused due to the occupation in the course of employment causing disability or death of the employee.
The amount of compensation is based on the nature of the injury and the average monthly wages and age of workmen. In cases of death, the dependents of the workmen will get compensation. The minimum and maximum rates of compensation payable for death and for disability vary from case to case and are granted by the Commissioner of Compensations.
Now that minimum amount is now meaningless. Original law, it was 300 rupees. There is no compensation now as per Employees Compensation Act where any compensation of 300 is paid. There is no. Now that has been increased to 10,000. That is also in today's era, it is meaningless.
The law provides for circumstances where the employer is not liable to pay compensation to the employee. The employer need not pay compensation if the injury doesn't result in total or partial disablement of the worker for a period exceeding more than 3 days. The employer is not liable to pay compensation if the injury does not result in death or partial disablement. Employee is not eligible for compensation if the accident cause took place because the worker was under the influence of drinks or drugs at the time of accident. The employer is exempted from paying compensation in cases where willful disobedience of rules or orders given for the safety of the worker are violated. If the worker willfully removes the safety guard or other device which has been provided for the safety of the worker, he will not be eligible for compensation.
It certainly is something very good in this. Employers should inform at the time of the entry to the workers, this is the things what we will get, what is your right. Otherwise, they have to pay some fine.
The law applies to the organized sector like the railway staff, employees of factories and mines. Workers in plantation, employees of mechanically propelled vehicles, employees working in construction sector and certain other hazardous occupations are also covered under the law.
The amendments in the Employees Compensation Act were long due as there was an urgent need to revise penalties for the benefits of the employees. The bill will also have a huge impact in the organized sector as it will benefit around 3 crore workforce in the organized sector in the country. With cameraman Anirban, Dipali Pandit for Rajya Sabha Television.
The compensations have not been enhanced and continue to be meager according to the inflation that exists in modern times. That being the point, sir, 10,000 as he said. I mean, that's nothing. But no. I'll take you to also the issues where the the law actually states who all will not be eligible for compensation. That leaves a huge gap in the hands of the employer to even deny the workman of the 10,000 that probably it's rightfully his.
No, I think the gentleman, the MP gentleman did not say it correctly. Look, 300 rupees, you are scoffing now, but please see, 1923, 300 was a princely sum of money at that point of time.
No, it has been revised to 10,000.
Correct. I'm just talking about, he mentioned 300 rupees at that time.
But 10,000 is not a princely amount now.
No, 10,000 is a reasonable amount.
It's not even, it's not reasonable.
No, it all depends. It all depends how you view.
For death and disability,
no,
sir?
it is not 10,000. It is not 10. If you look at the death and the permanent disability or temporary disability, the Act has a schedule. So if you lose a thumb, it is 30% or 10%.
Correct.
If you lose an index finger, it is 5%.
It varies.
So
it varies.
So it is not that in every case you only get 10,000. It all depends. If it's a permanent disability, it is 60% of your last pay drawn.
Correct.
So it is not that. And it all depends, varies about where you are. Now, suppose a man is alcoholic and he comes on duty. He is not going to get any compensation under this Act. Maybe tortious liability under tort, he can file a civil suit, whatever. But these are statutory compensation which is mandatory for an employer to pay while you are working in his factory or in the railways, depending, etc., where you work, mines, etc. So I think the bill has taken good care of making the necessary changes.
Ma'am, I'll bring to your comments on this. Now, there could be a language, let's say English language used in all factories where warnings are given, don't do this, don't do that, safety manuals are there in a language that may not be the language of the worker.
Yes.
But the employer can make use of this provision to deny the worker of that he did not follow the norms prescribed. Do you feel that is a possibility?
That might be a possibility. That might be a possibility, but more intruding into is that we have cases. Maybe there are lots, especially in auto parts. Major to minor accidents occur because of worker not getting proper protection, those instruments and all. Sometimes what happens is that Yes, the point should be mentioned like in electorate that to avoid this area and English or local language where the worker will be able to understand. The factory management has to take care of this. The factory is located in Haryana, and if the workers are mainly from Bengali community, then the management language should be where the workers should understand, and an instructor has to explain everything. This is a thing which can be pointed, but more to then is that we have cases of many workers working in auto parts getting these minor accidents. When these accidents were taken, why is it that they were not taken to the hospital directly? Or if they report the matter, instead they get harassment.
I get your point. So
This
what
is a
happens to
practical
the
point.
minor injuries and 3 days if the person is fined before 3 days?
Then you
So-
don't get under the, look.
So you don't
the
get
statute.
anything at all?
Not under the statute. Look, you please understand, this statute is like an emergency payment to be made. It is not something which will come leisurely. Now you fall ill for 2 days. You get casual leave, you get medical leave if you are an employee, not in a factory but in an office, etc., etc. So you are covered. But yes, if that injury is caused and you are in bed for more than 3 days, then the statute says compensation must be given. Look, compensation is not something like you grab. It's like a lottery that you get 5 times the money. Please don't understand. This act was made that when a worker who works is
And there's
injured,
something serious that
correct,
happens.
serious,
He's compensated.
So he's compensated.
Yeah.
That's the point.
Moving on, my colleague Dipali Pandit spoke to Subhomoy Bhattacharjee, contributing editor, Business Standard, and tried to get a sense of this entire law.
The bill makes it obligatory to the employer to inform its employees about their rights to compensation, failing which they will be liable to penalties. How do you look at this step?
Written contract and letting the persons know under which contract or under which terms somebody has been employed is always a good idea. It avoids miscommunication. It ensures that both are on even keel. And sure, I mean, a contract which is made explicit is anytime a better idea than a contract which is verbal, oral. You don't know what are the terms on which people are coming out. So fair enough.
The bill enhances penalties for various violations of the Act. Do you think the proposed amount is sufficient?
The problem with most of our bills, acts rather, when we try to bring them in, is that we tend to bring in penalties but do not bring in the enforcement machinery necessary to implement them. So if an act has to be successful, let's look at what happens in a traffic violation. Now, if there is no traffic policeman, then no matter whatever is the fine for crossing a red line, the incentive to jump the red line is much higher. So it's the same out here. If the state is sure that it needs to impose a penalty, then the state should also be sure that it has the ability to enforce that penalty.
And thank you, sir and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Savati.